live. Thank you for watching and for joining me on this video today. It is Sunday the 17th of September. If you are listening to this, then I hope you've recharged and you're ready for the week ahead. And good morning, good afternoon, or good evening, wherever you are and whenever you may be listening to this. Today's video is a legal brief on the case of Bernstein versus DOJ. And why that case? Well, actually, that's because Richard Hart called on the crypto lawyers to take a look at a list of these cases that he tweeted. And the very first one is Bernstein versus DOJ, in that cryptocurrency code is protected speech. Now, Bernstein versus DOJ is actually a case that goes back to 1996, but it's relevant today in the restrictions that crypto projects like Hex, Pulse Chain, PulseX have been facing from the SEC in regulating and restricting. And the landmark decision of the courts in 1996 is that code is speech protected by the First Amendment. And of course we know that Hex, Pulse Chain and PulseX are immutable smart contracts. So they are in essence code. And so that is why these cases are actually very relevant in light of the SEC's latest complaints against Richard Hart. And so I'm doing this to hopefully help the community, and I hope that you will find this video of benefit as we really take a deep dive into the decision and the reasoning of the court. We're actually going to go through it into how they came to the conclusion that code is speech, and you'll see some very interesting references to music and copyright when comparing code to a form of expression such as speech that is protected by the First Amendment. And of course this can apply to other jurisdictions like South Africa, where I'm from, where free speech is also a constitutionally protected right. Before we go into that though, if I can just briefly introduce myself. I am Janie Taylor. I'm a believer of Jesus Christ. I'm a mother of a 9-year-old son, and I am married. And I'm very passionate about crypto. I've been in crypto since 2014, where me and my husband, we got our first Bitcoin, and we also got into Colossus. I remember buying Colossus coins. So leave a comment if you're one of those that bought Colossus. Unfortunately though, I fall into that crowd of people that lost their wallet. Yay. And my husband says it was my fault, but I say it was his, and of course I'm right. Anyway, so I got into Hex on day 613, and of course subsequent to that I made the sacrifice for Pulse Chain for freedom of speech and PulseX for freedom of association. And being a legalist, these are values, even if you're not actually in the legal profession, I think they're values that we can all take to heart and value, and it's not something that should be taken easily for granted. And yeah, actually Richard Hart was the person that introduced us to DeFi, because up until then I didn't have a clue how to use MetaMask or Uniswap, and it was, I must say, quite intimidating learning those things from scratch. But thanks to him we actually got out of exchanges, and it has really truly opened up a whole new world to us of DeFi and moving out the middleman, which is what the vision of Satoshi was. So that's my crypto history, and I also have an LLB degree, and bringing in my two passions, which is crypto and wanting to make a difference in the world and help people. I hope that you will join me on this journey in bringing the two worlds together to make the world a better place. So this is the tweet from Richard Hart, and then I just wanted to briefly discuss who Bernstein is. I mean, if we take a look at this article, it describes him as someone who has actually given a lifetime dedicated to citizens' rights to privacy. And actually currently he's a professor, but when he started this case on about 1995, he was at that time a PhD candidate in mathematics at the University of California at Berkeley. This is now his Twitter page if you want to follow him. He is, if we can appreciate where we are in the world today, he is a leader and someone who can fight for our rights in free speech and freedom of expression, such as Hex, PulseChain, and PulseX. So I'm following him, and basically to give him a bit more of a background to him, at the time that he brought that application, he was working in the field of cryptography, and that is basically, the court describes an area of applied mathematics that seeks to develop confidentiality in electronic communication. And what happened at that time, which led to the bringing of the case, was he had developed an encryption algorithm which he called Snuffle. And what he wanted to do was he wanted to share that. He had articulated it into an academic paper and also into source code written in C. But the problem he faced was that because of the Arms Export Control Act and the International Traffic in Arms regulations, he wasn't allowed to. And that is what he challenged as unconstitutional and a restraint on freedom of speech and essentially expression. So I think we are now ready to get into the case. I just want to also just bring in a bit of context into this case, because there was a number of decisions actually in this case. It ended in the U.S. Court of Appeals for the Ninth Circuit, but before that it had been in the District Court. So you can see here, this is the decision of the Court of Appeals, which I'm reading from here. It says the District Court found that source code was speech protected by the First Amendment, and they refer to that as Bernstein 1. So that's the case we're going to be reading today, because that is the case that really gets into the meaty substance of why source code is protected speech. But there was a subsequent decision also in the District Court, where he was granted summary judgment on his First Amendment claims. That would be Bernstein 2. And then, of course, it went to the Court of Appeals. And if we quickly go up here, the Court of Appeals held that the challenged regulations constitute a prior restraint on speech that offends the First Amendment. So although we're not going to be reading the decision of the Court of Appeals in this video, we know that ultimately they agreed with the decision of the District Court over here, and that is the decision we're going to be reading from today. So let's get into it. Okay, so in this decision that the court was dealing with, there was a motion by the defendant, or the DOJ, to dismiss for lack of justiciability. So I'm not going to go into everything in this case. The main thing is that we get to the court's decision that code is protected speech. So you'll see that Bernstein, he had made a number of arguments. One of them was speech. He also made an argument about prior restraint, about overbreadth and vagueness, and the court doesn't actually make in this decision that we're going to read any final decisions on those, because it was actually a motion to dismiss for lack of justiciability. But the court was very firm in its decision that code is protected speech. So just an interesting description here of cryptography by the court. The court says that the uses of cryptography are far-ranging in an electronic age, from protecting personal messages over the internet and transactions on bank ATMs to ensuring the secrecy of military intelligence. This part here, military intelligence, was where he had the problem, because what happened was the Arms Export Control Act, it authorized the president to control the import and export of defense articles and defense services by designating such items to the United States Munitions List, the USML. And what happened here was that categories of items covered by that USML included cryptographic systems, equipment, assemblies, modules, integrated circuits, and so on. So what he did, Bernstein, was on August the 20th, 1992, he was informed after he had written a letter to them asking whether he could distribute his academic paper and his source code. The ODTC informed Bernstein that after consultation with the Departments of Commerce and Defense, it had determined that the commodity snuffle 5.0 was a defense article under Category 8 of the ITAR and subject to licensing by the Department of State prior to export. So that was the predicament he faced. What he did was he then followed up, still unsure if his academic paper had been included in the ODTC CJ determination of August 20th, 1992. Bernstein submitted a second CJ request on July 15, 1993. On October the 5th, 1993, the ODTC notified Bernstein that all of the referenced items were defense articles under Category 8B1. And so basically that's what led to his bringing of the application to the court. It says here that Bernstein seeks to publish and communicate his ideas on cryptography because export under the ITAR includes disclosing technical data to a foreign person, whether in the United States or abroad. Bernstein asserts that he is not free to teach the snuffle algorithm, to disclose it at academic conferences, or to publish it in journals or online discussion groups without a license. And so that's ultimately what led to the debate about whether this was an unconstitutional infringement on freedom of speech. This is his argument. The plaintiff, which is Bernstein, alleges that the acts and accompanying regulations, both facially and as applied, are a content-based infringement on speech, act as an unconstitutional prior restraint on speech, are vague and overbroad, and infringe the rights of association and equal protection, because he wasn't free to distribute them. And I'm just going to scroll down. So this is what the defendant had to say. Defendants maintain that the plaintiff, Bernstein, has raised no colorable constitutional claim. because this case does not concern speech protected by the First Amendment, and even if it does, the minimal infringement is excusable. So they were saying it was not speech. Okay, and now we get to the really interesting part of this decision, where the court decides that code is protected speech. Okay, the paper, an academic writing explaining Bernstein's scientific work in the field of cryptography, is speech of the most protected kind. So already they're making quite a bold statement, and they're even referring to another case of Sweezy versus New Hampshire, where they're specifically noting the importance of protecting scholarship and academic inquiry. Rather, defendants contend that Snuffle and Unsnuffle, the source code for the encryption program, are not speech but conduct. Bernstein argues that computer code inscribed on paper like any non-English language is speech protected by the First Amendment. Plaintiff further argues that even functional software is treated as protectable expression under copyright law. Defendants urge this court to find the source code for Snuffle unprotected conduct rather than speech. So they were coming from an angle that it's not actually speech, it's conduct. And we'll see now why they said that shortly. But what they did was they cited the case of Texas versus Johnson for the proposition that conduct must be, quote, sufficiently imbued with the elements of communication to fall within the protections of the First Amendment. And so basically what happened in that in that case was there had been a burning of a flag, and what they tried to do in that case was they tried to see whether it was imbued with elements of communication in sending out a message, so that it would constitute, for example, speech, even though it was conduct in the sense of burning a flag. In evaluating the cumulative aspects of burning a flag in Texas versus Johnson, the court framed the inquiry as whether the conduct entails an intent to convey a particular message and the likelihood of that message being understood. According to the defendants, the source code as a functioning cryptographic product is not intended to convey a particular message. It cannot be speech, they say, because its purpose is functional rather than communicative. However, the courts in both Johnson and Spence, the flag desecration case upon which Johnson relies, inquired into the communicative nature of conduct only after concluding that the act at issue was indeed conduct and not speech. Both cases strongly imply that a court need only assess the expressiveness of conduct in the absence of the spoken or the written word. So that might sound a bit confusing to you, but basically what they're saying is only if it's an action, was it in the sense of conduct, was it necessary to establish the communicative extent of that conduct, like was there a message behind that conduct that would allow the court to say, yes, actually that conduct falls within speech rather than just purely conduct, right? But the issue there was that it wasn't speech, it was the burning of a flag. And what the court says here is that the court need only assess the expressiveness of conduct in the absence of spoken or written word. So, what they said in those cases with the burning of the flag was, to be sure, appellant did not choose to articulate his views through printed or spoken words. It is therefore necessary to determine whether his activity was sufficiently imbued with elements of communication to fall within the scope of the First and 14th Amendments. So it was only after the court had ruled that it was conduct and not speech in the most direct, narrow sense of the word, was it necessary to see whether that conduct was imbued with communication. However, in the instant case, meaning the case before the court, which is Bernstein, the court said the following: Bernstein's encryption system is written, albeit in computer language rather than in English. Furthermore, there is little about this functional writing to suggest it is more like conduct than speech. So already the court is saying there's no need to assess whether it was because it's a computer program or it's code, that there's a functional element to it. Therefore, we need to establish whether there's a message trying to be conveyed. The court is already saying it is speech. It's more speech than conduct. The court says a computer program is so unlike flag burning and nude dancing that the defendant's reliance on conduct cases is misplaced. It would be convoluted indeed to characterize snuffle as conduct in order to determine how expressive it is. At least formally it appears to be speech. So the court's saying it's speech. Recently, the Ninth Circuit addressed the difference between speech and expressive conduct in assessing the constitutionality of the English-only provision amended to Arizona's constitution. And this was the case of Negaz. Sorry if I'm pronouncing that incorrectly. So, the defendants in Negaz, like the defendants here, sought to characterize one's choice of language as expressive conduct. The court, however, was similarly unpersuaded by the comparison between speaking languages other than English and burning flags. The court further concluded that language was speech by definition. Of course, speech in any language consists of the expressive conduct of vibrating one's vocal cords, moving one's mouth, and thereby making sounds, or of putting pen to paper or hand to keyboard. Yet, the fact that such conduct is shaped by language that is a sophisticated and complex system of understood meanings is what makes it speech. Language is by definition speech, and the regulation of any language is the regulation of speech. And then the court goes on to say that nor does the particular language one chooses change the nature of language for First Amendment purposes. This court can find no meaningful difference between computer language, particularly high-level languages as defined above, and German or French. All participate in a complex system of understood meanings within specific communities. Even object code, which directly instructs the computer, operates as a language. When the source code is converted into the object code language, the object program still contains the text of the source program. The expression of ideas, commands, objectives, and other contents of the source program are merely translated into machine-readable code. Whether source code and object code are functional is immaterial to the analysis at this stage. Contrary to the defendant's suggestion, the functionality of a language does not make it any less like speech. The Negaz court noted that the choice to use a given language may often simply be based on a pragmatic desire to convey information to someone so that they may understand it. Thus, even if Snuffle source code, which is easily compiled into object code for the computer to read and easily used for encryption, is essentially functional, that does not remove it from the realm of speech. So this is very important what the court's saying here. And it even compares it here. instructions, do-it-yourself manuals, recipes, even technical information about the hydrogen bomb construction are often purely functional. They are also speech. And then the court goes on to compare code to music and copyright laws. So here the court says music, for example, is speech protected under the First Amendment. And listen here to how the court makes comparison between source code and music and how they work, and actually their similarities, which support the court's conclusion that source code is speech. So the court says, the music is inscribed in code on the roll of a player piano is no less protected for being wholly functional. Like source code converted into object code, it communicates to and directs the instrument itself, rather than the musician to produce the music. That does not mean it is not speech. Like music and mathematical equations, computer language is just that, language, and it communicates information either to a computer or to those who can read it. This is very simple logic that the court applied. The defendants argue in their reply that a description of software in English informs the intellect, but source code actually allows someone to encrypt data. Defendants appear to insist that the higher the utility value of speech, the less like speech it is. An extension of that argument assumes that once language allows one to actually do something, like play music or make lasagna, the language is no longer speech. Now that's actually quite absurd, and the court says exactly that. So the logic of this proposition is dubious at best. Its support in First Amendment law is non-existent. Now this is where they go into copyright law, and this is also very interesting, the comparison here that the court makes between source code and copyright law. And keep in mind all of this in relation to crypto. By analogy, copyright law also supports the expressiveness of computer programs. Computer software is subject to copyright protection as a literary work. And then they've backed it up here. For the purposes of copyright, literary works are works other than audiovisual works expressed in words, numbers, or other verbal or numerical symbols or indicia, regardless of the nature of the material objects, such as books, periodicals, manuscripts, phone records, film tapes, discs, or cards in which they are embodied. A computer program is further defined under the copyright statute as a set of statements or instructions to be used directly or indirectly in a computer in order to bring about a certain result. Source code is essentially a set of instructions that is used indirectly in a computer, since it must first be translated into object code to achieve the desired result. The statutory language, along with the case law of numerous circuits, supports the conclusion that copyright protection extends to both source code and object code. Copyright protection, designed to protect original expression, supports the likeness of a computer program to speech as defined by the First Amendment law. The expression of an idea, as opposed to the idea itself, which is not afforded copyright protection, connotes the speaking of an idea, which is exactly what Bernstein did. An encryption program expressed in source code communicates to other programmers and ultimately to the computer itself how to make the encryption algorithm functional. Nor under copyright law does sheer functionality diminish the expressive quality of a copyrightable work. So what, in summary, the court is saying here is that copyright law supports that source code, which falls under copyright, is a form of expression. Then the court says here, while copyright and First Amendment law are by no means coextensive, and the analogy between the two should not be stretched too far, copyright law does lend support to the conclusion that source code is a means of original expression. And we get to the best part of this decision, which is basically the court's conclusion that, for the purposes of First Amendment analysis, this court finds that source code is speech. Now, this is fantastic for us in the crypto community. It is something that we can absolutely use to our advantage. And you can see how, even though this was actually just a case dealing with justiciability of the case that the defendant had brought, in other words, the court wasn't getting to the final issues of the case yet. It was deciding whether there was merit to the claim. The court was very, very firm in its decision and unwavering that source code is speech. Now, I'm just going to, before we end this analysis, because there's one more important thing in this judgment that's actually very important for and very relevant for purposes of today in the world of DeFi and the SEC, is the rest of the arguments made by Bernstein. So I'm not going to cover O'Brien, we're just going to skip that because that was actually an argument by the defendant. So we're going to go down to prior restraint. Now I've done some videos on this. They're actually not too long. So one of them was a short and one was just under 2 minutes. Now, let's just read what the court said here and then I'll explain why this is actually also a tool that we can use today. Plaintiff alleges that the AECA and the ITAR act as an administrative licensing scheme. Pause. Does that sound like the SEC? Administrative licensing scheme. And now I'm going to carry on. For the publication of scientific papers, algorithms, and computer programs related to cryptography, or DeFi projects related to cryptography. Okay, I'm carrying on. Since publishing could release that information to foreign persons and would constitute exportation under the ITAR. Now, listen to this very carefully. Governmental licensing schemes, such as the AECA and ITAR, or a possible argument, the SEC, which requires licensing of securities, so-called alleged securities. This is what the court has to say about institutions and schemes such as this. They come with a heavy presumption against their validity when they act as a prior restraint on speech. And the court refers to a case here, actually a number of cases. So, when they act as a prior restraint on speech, crypto, hex, pulse chain, pulse X is code equals speech protected by the First Amendment. When governmental licensing schemes silence DeFi projects such as Hex, Pulse Chain, and Pulse X, we could very well argue that there is a heavy presumption against their validity because it's already been decided by these cases. Because what it's doing is this licensing requirement of the SEC is restricting freedom of speech. And if we look into the complaints against Richard Hart One of their claims is that he's defrauded investors. What rug pull? Pulse Chain launched. Hex launched. There's been absolutely no problems. The code, the freedom of speech is working 100%. There was no misrepresentation. We all knew what we were sacrificing for, and we all knew when we were sacrificing that there was no reasonable expectation of profit from the work of others. So yeah, that's, I think, possibly, but again, this is just for informational purposes. This is not legal advice. I think this is possibly a very good argument to bring in. And by no means am I saying that institutions like FTX and Celsius, they shouldn't be held accountable. But when I hear Gary Gensler saying things like, the crypto space has cost consumers billions of dollars, yeah, FTX and Celsius did, but what has Richard Hart done wrong? What has Hex done wrong? What has Pulse Chain done wrong? What has PulseX done wrong? And they're confusing CeFi from DeFi. And that's where they, I believe, are undermining and infringing on our rights. And we have cases like this to back up and support our view. And that's why it's so important that we go through these cases and we understand them so that we can work together as a community. So the rest of the decision, like I say, the court doesn't really come to any other final conclusions because this wasn't actually getting to the final issues of the case. The main points that I think are the most important from this case is that, number one, source code is speech, protected speech. It's how we can apply that to crypto today, to DeFi, and it's thinking about and developing on this concept of prior restraints and how the SEC has been conducting itself against these crypto projects. I think that is it for today's video. I really hope you enjoyed it and that it has been of benefit to you, and I will definitely see you in the next one. I hope you enjoy the rest of your evening or your day, and I'll see you soon.